This agreement also contains a provision that's blatantly discriminatory towards non-parties. Now, I want you to deal with that and deal with the fact that I think, please comment on that, on this basis alone, the judge should have found in our favor. Yeah. If we brought this application on this basis alone, he should have said this agreement cannot go to the minister. But just to give us your comment on that.
So basically what the agreement states is that there's a new phase-in exemption contained in the agreement, which basically states that employers who in the past did not pay the prescribed wage rates as a result of them not being bound by it due to NEASA having set aside or stopped the extension of those agreements, can apply to phase in their wages to 60% of the current wage rate as prescribed by this agreement over the duration of the period of the agreement. However, this is not an automatic exemption. It's not a blanket exemption. You will have to apply annually to do so, to get this exemption, and you have to prove that you have financial difficulties. So it's no different from the previous or even current struggling business exemption. We have to say, well, I can't afford these wages. Here are my financials, so please exempt me. The discriminatory problem with this is that the agreement states that this phase-in exemption is only available to signatories of the agreement. So only those organizations affiliated to CIFSA and to CEO who also signed the agreement can apply, which is a clear violation of the LRA, because the LRA stipulates that an agreement may not have provisions that discriminates against non-parties. This is a blatant discrimination against non-parties. So this is something that the judge should have taken into account and says, but you can't extend this agreement with this type of provision in it. But the judge went ahead and said, well, I don't need to deal with it. That's something the Minister of Labour needs to look at. The problem is if the Minister decides not to heed our call and say, well, you're correct, then we've got an extended agreement and we have to deal with that agreement for 2 years until we're able to set aside his review. Now, it's interesting the judge says, well, I don't have to deal with it because you've got an alternative remedy in that, one, you can review the Minister, which I just said was going to take 2 years, and secondly, he says when you are successful, or if you are successful against the Minister, you can recoup your wages.
How is that possible?
So theoretically, by law, it's possible. Practically, it's not possible.
Of course not possible. 2 years later, you want to recuperate that money from an employee. That's impossible. You know, that is, with respect, somewhat impractical is a very appropriate word for this, but there's stronger words for that. On that basis alone, the judge should have said this thing cannot go through.
In our view, there's no alternative remedy. His alternative remedy is not a proper alternative remedy.
Now we've had a situation in the past where a judge, and that was in I think 2011, when we brought an urgent application, and the judge said, no, you know what, I'm not going to hear you on this thing because if the Minister extends, then you can sort it out then. Well, it's not possible. It's not possible. Once you've paid that wages, then you've paid it. You'll never get it back.
And that was an application in terms of an administration agreement, so it was only for admin levies. This situation is much, much worse. It's in terms of wages and LEP and all that. So it's a much larger amount that you are now allegedly able to recover if you're successful.
Absolutely.
Doesn't make sense.